Good day, sir. I'm Kinkin Trimidal, and I'm gonna read the Article 14 and 15 of Revised Penal Code. And the purpose of this recording is to serve our activity, which is Article 14 and Article 15 in Revised Penal Code. So, Article 14, aggravating circumstances. The following are aggravating circumstances. 1. That advantage be taken by the offender of his public position. Requisites. The offender is public officer. The commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. The categories is essential. Public officer used the influence, prestige, or ascendancy which his office gave him as means by which he realized his purpose. Failure and official in tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position. Number 2 is that the crime he be committed in contempt of or with insult to the public authorities. Requisite. Number 1 is the offender knows that the public authority is present. Number 2 is the public authority is engaged in the exercise of his function. Number 3, the public authority is not the victim of the crime. Number 4 is the public authorities' presence did not prevent the criminal act. Example, Juan and Pedro are quarreling the municipal mayor upon passing by attempts to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeeds in killing Pedro. Number 2 is person in authority. Public authority who is directly vested the jurisdiction has the power to govern and execute the laws. Example of person in authority. Number 1 is governor, 2 is mayor, number 3 barangay captain, number 4 is councilors, number 5 government agents, number 6 is chief of police. Rule not applicable when committed in the presence of a mere agent. Subordinate public officer charged with the maintenance of public order and protection and security of life and property. Example, barrio vice lieutenant, barrio councilman. Number 3, that the act be committed. Number 1 is with insult in disregard of the respect due to the offended party on account of his A. rank, B. age, C. sex, or number 2 is that it be committed in the dwelling of the offender party if the latter has not given provocation. Circumstances. Rank, age, sex may be taken into account only in crimes against person in honor. It cannot be invoked in crimes against property. Rank refers to the high social position or standing by which to determine one's pay and emoluments in any scale of comparison within a position. Age. The circumstances of lack of respect due to age applies in case where the victim is of tender age as well as of old age. 6 refers to the female sex, not the male sex. Not applicable when number 1 is the offender act with passion and obfuscation. Number 2 is there exists a relation between the offender and the victim, but in case of divorce, decrees where this is direct bearing in their child. it is applicable. Number 3, the condition of being a woman is indispensable in the commission of the crime. Example, parricide, rape, abduction. Requisites of this disregard to rank, age, or sex. Number 1 is crime must be against the victim's person or his honor. 2, there is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Disregard to rank, age, or sex is absorbed by treachery or abuse of streets. Dwelling must be a building or construction exclusively used for rest and comfort. Combination house and store not included. Number 1 is may be temporary, as in the case of guests in a house or bed spacer. Number 2 is basis for this is the sanctity of privacy. The law accords to human abode. Dwelling included dependencies, the foot of the staircase and the enclosure under house. Elements and aggravating circumstances of dwelling. Number 1 is crime occurred and dwelling of the victim. Number 2 is no provocation in the part of the victim. Requisites for provocation, all must concur. Number 1, given by the owner of dwelling, sufficient. Number 3 is immediate to the commission of the crime. When dwelling may and may not be considered. When it may be considered. When it may not be considered. So, although the offender fired the shot from outside the house, as long as his victim was inside. Even the killing took place outside the dwelling, so long as the commission began inside the dwelling. When adultery is committed in the dwelling of the husband, even if there is also in the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the house. In the robbery with violence against person, robbery with homicide, abduction, or illegal detention, if the offended party has given provocation. When it may be not considered, first is the victim is outside her dwelling. Number 2 is if offended party are not occupants of the said dwelling. When it may be considered is if the both offender and the offended party are occupants of the same dwelling. In robbery with force upon things, it is inherent. Wherefore, that the act be committed with, number 1 is abuse of confidence, or 2 is abuse ungratefulness. Requisite of abuse of confidence is A. Offended party has trust the offender. B. is offender abuse such trust. C. Abuse the confident facilitate the commission of the crime. Requisite of abuse ungratefulness. A is ungratefulness must be obvious that there must be something which the offender should owe the victim deep of gratitude for. Note, robbery or theft committed by a visitor in the house of the offended party is aggravated by abuse and ungratefulness. Example, a jealous lover already determined to kill his sweetheart invited her for a ride, and during that ride he stabbed her. 2 is abuse of confidence is inherent. Number 1, malversation, qualified thief, estafa by conversion, misappropriation. 5 is qualified seduction. Number 5, that the crime be committed in public palace of the chief executive or in his presence or when public authorities are engaged in the discharge of their duties or in the place of dedicated to religious worship. Requirements of the aggravating circumstances of public office. First is polling present is a public office during election day. Second is nature of public office should be taken into account, like a police station which is on duty 24 hours a day. Third is place of the commission of the felony. Paragraph 5. If it is Malacanang Palace or a church is aggravating, regardless of whether state or official functions are being held. Fourth is, as regards other place where public authorities are engaged in the discharge of their duties, there must be some performance of public function. Fifth is, the offender must be intention to commit a crime when he entered the place. Requisites of aggravating circumstances for place of worship. Number 1 is the crime occurred in the public office. Number 2 is public authorities are actually performing their public duties. The crime occurred in the place dedicated to the worship of God regardless of religion. So his offender must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 are of Article 14 are applicable, committed in the presence of the chief executive in the presidential palace or place of worship, paragraph 5 of Article 14. Public authorities are performing of their duties when the crime committed. When crime is committed in the public office, the officer must be performing his duties except in the presidential palace. Public authority may be the offended party. Committed in contempt of public authority. Paragraph 2, Article 14. Same. Outside the office is still performing duty. Public authority is not be the offended party. 6A is the crime be committed in the nighttime or in the an uninhabited place by a band whenever such circumstances may facilitate the commission of the offense. Nighttime uninhabited place or by a band aggravating when impunity means to prevent the accused being recognized or to secure himself against detection of punishment. Second is nighttime begin as the end of dusk and ending at dawn from sunset to sunrise. Third is uninhabited place, one where there are no houses at all, a place at a considerable distance from town, where the houses are scattered at a great distance from each other. Number 1 is it facilitated the commission of the crime. Number 2 is especially so for by the offender to ensure the commission of the crime for the purpose of impunity. Force commission of the crime must have been begun and accomplished at night time. Number 1. The commission of the crime must begin and be accomplished in the night time. When the place of the crime is illuminated by light, night time is not aggravating. Number 3 is absorbed by treachery. Requisite: the place facilitates the commission of the or omission of the crime. Number 2, deliberately sought the not essential of the commission of or omission of the crime. 3, taking advantage for the purpose of impunity. What should be considered here whether in the place of the commission of the offense there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Requisites: if one of the 4 armed malefactors is a principal by in document, they do not have form a band because of it is adoptly cannot that he had no direct participation. Third is band is inherent in robbery committed in the band and brigandage. It is not considered in the crime of rape. It has been applied in treason and in robbery without homicide. 1. Facilitate the commission of the crime. 2. Deliberate sooth. 3. Taking advantage of for the purpose of impunity. 4. There must be 4 or more armed men. 7. That the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Requisites: 1. Committed when there is a calamity or misfortune, conflagration, shipwreck, epidemic. Offender took advantage of the state of confusion or chaotic condition from such misfortune. Basis commission of the crime adds to the suffering by taking advantage of the misfortune. Based on time, offender must take advantage of the calamity or misfortune. Distinction between paragraph 7 and 12 of Article 14. Committed during calamity or misfortune. Crime is committed during any of the calamities committed with the use of wasteful means. Crime is committed by using fire, inundation, explosion, or the wasteful means. 8. That the crime be committed with the aid of 1 armed man or 2 persons who ensure or afford impunity based on the means they and ways. Requisites: that armed men have or person took a part in the commission of the crime directly or indirectly. 2. That the accused availed himself of their aid or relied upon them when the crime has committed. Exceptions: 1. When the both attacking party and the party attacked were equally armed. 2. Not present when the accused as will those cooperate with him in the commission of the crime act under the same plan and for the same purpose. 3. Casual presence or when the offender did not avail himself of any of their aid nor did not knowingly count upon their assistance in the commission of the crime. With the aid of the armed men present of one of the offender merely relied in their aid, actual aid is not necessary. By a band requires more than 3 armed malefactors who all act together in the commission of an offense. If there are more than 3 armed men, aid of armed men is aborted in the employment of a band. Number 9 is that the accused is recidivist. Recidivist, one of at the time is of his trial for one crime shall have been previously convicted by final judgment of another crime embracing the same title of the RPC or Revised Penal Code. Basis greater perversity of the offender as shown by his inclination to commit crimes. Requisite: offender in the trial for an offense. 2. He has previously convicted by final judgment of another crime. 3. That both the first and the second offense second offenses are embraced in the same title of the RPC or Revised Penal Code. The offender is convicted in the new offense. Recidivism must be taken into account no matter how many years have been intervened between the first and second felonies. Pardon does not obliterate the fact that the accused was a recidivist, but amnesty extinguishes the penalty and its effects. To prove recidivism, it must be alleged in the information and the attached certified copies of the sentences rendered against the accused. Exception: the accused does not object and when he admits in his confession and on the witness stand. 10. That the offender has been previously punished for an offense to which the law attached an equal or greater penalty, or for two or more crimes to which attach a lighter penalty. Reiteration or habituality. It is essential that the offender be previously punished, that is, he has served sentence. Paragraph 10 speaks of penalty attached in the offense that not penalty actually imposed. Reiteration. Necessary of that offender shall have reserved out his sentence for the first sentence. Recidivism is not that a final judge has been rendered in the same offense. Reiteration. Previous and subsequent offense must not be embraced in the same title of the code. Recidivism, same title. Reiteration. Not always in aggravating circumstances. Recidivism, always aggravating. Habitual delinquency. When a person within a period of 10 years from the date of his release of last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification is found guilty of any of said crimes a third time or oftener. Quasi-recidivism. Any person who shall commit a felony after having been convicted by final judge before beginning to serve such sentence or while serving the same shall be punished by the maximum period of the penalty prescribed by law for the new felony. 4 forms of repetition. Number 1 is recidivism, generic. Second is reiteration or habitually generic. 3 is multiple recidivism or habitual delinquency, extraordinary aggravating. 4. Quasi-recidivism, especially aggravating. 11. That a crime be committed in the consideration of a price, reward, or promise. Requisites. At least 2 principles. Number 1 is the principle by endorsement. Number 2 is the principle by direct participation. 3 is the price, reward, or promise should be previous to and in consideration of the commission of the criminal act. Applicable to both principles. 12. That the crime be committed by means of inundation, fire, poison, explosion, stranding a vessel, or intentional damage thereto, or derailment of a locomotive, or by use of any other artifice involving great waste or ruin. Requisite. The wasteful means were used by the offender accomplish a criminal purpose. Number 13, that the act be committed with evident premeditation. Essence of premeditation. The execution of criminal act must be preceded by cold thought, that reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. Requisite. First is the time when the offender determined to commit the crime and the act of manifestly indicating that the culprit has clung to his determination. 3. Uh, 3. Uh, Sufficient lapse of the time between the determination and execution to allow him to reflect upon the consequences of his act and allow to his conscience to overcome the resolution of his will. The conspiracy generally presupposes premeditation. When victim is different from that intended, premeditation is not aggravating. Although it is not necessary that there is a plan to kill a particular person for premeditation to exist. Plan to kill first two person, one meets general attack and on a village for as long as it was planned. The premeditation must be based upon external facts and must be evident, not merely suspected, indicating deliberate planning. Evidented premeditation is inherent in robbery, adultery, thief, estafa, falsification, and etc. 14. That one craft, number 2, fraud, or 3, disguise be employed. Craft involves intellectual trickery and cunning on the part of accused. It is employed in a shame in the execution of a crime. Accused pretended to be member of the constabulary. Accused accused in order to perpetrate rape use chocolates containing drugs. Fraud involves a insidious word in the mechanication used in induce victim to act in a manner which would enable the offender to carry out his design. As distinguished from craft which involved acts done in order not arouse in the suspicion the victim, fraud involved directly inducement through entrapping or beguiling language or mechanication. Distinction between craft, fraud, and disguise. Craft involves the use of intellectual trickery and cunning to arouse suspicious of the victim. Fraud involves the use of direct inducement by insidious words or mechanizations. Disguise involves the use of device to conceal, identify. Requisites: the offender must have actually taken advantage of bribe, fraud, or disguise to facilitate the commission of the crime inherent in estafa and falsification. 15. That the advantage be taken or of superior straits or means employed to weaken the defense. To purposely use excessive force in the proportion of the means of defense available to the person attacked. Requisites of manner to weaken defense. 1. Means were purposely sought that weaken the defendant of the victim to resist the assault. 2. The means of use not totally eliminate possible defense of the victim, otherwise it will fall under treachery. To weaken the defense, illustrated the case where just struggling with others suddenly throw the clock over the head of his opponent, and while the said situation he would or kills him. Other means with weakening the defense would be intoxication or disabling through the sense. 1. Superiority must arise from aggression, sex, weapon, or number as compared to that victim. 2. Advantage of superior strength when who attack in the overcome with passion and avocation, or when quarrel arose unexpectedly and the fatal blow was struck while victim as accused were struggling. 3. Versus by a band. Circumstances of abuse of superior strength. What is taken into account is not the number of aggressors nor the fact that they are armed, but their relative physical might vis-a-vis the offended party. 16. That the act be committed with the treachery, alivusia. Treachery. When the offender commits in any the crime against the person employing means, method, or form in the execution thereof which tend directly and especially to ensure the execution without risk to himself arising from the defense which the offended party might make. Requisites that at the time of the attack the victim was not in the position to defend himself. 2. That the offender consciously adopt the particular means, method, or form of attack employed by him. Treachery cannot be considered when there is evidence that the accused fired to the moment of killing, resolved to commit the crime or there is not proof that the death of the victim was not result of meditation, calculation, or reflection. Example, victim asleep, half awake, or just awakened. Victim grappling or being held, attached by behind. But treachery may exist even the attack is face-to-face as long as the victim was not given any chance to prepare defense. Does not does not exist if the accused gave the deceased chance to prepare or there was warning given to that it was preceded by a heated argument. 2. There is always treachery in the killing of child. 3. Generally characterized by any deliberate and sudden and unexpected attack of the victim from behind, without any warning and without giving the victim an opportunity to defend himself. Treachery. Means, method of the form are employed by the offender to make it impossible or hard to the offended party put in a sort or resistance. Abuse of superior strength. Offender does not employ means, methods of or forms of attack. He only take advantage of his superior strength. Means employment to weaken defend. Means employment but it only materially weakens the resisting power of the offender party. Where the conspiracy, treachery is considered against all the offender. Treachery absorb abuse of strength, aid of armed men by a band and means to weaken the defense. 17. The means be employed or circumstances brought about which an ignominy to the natural effect of the acts. Ignominy is the circumstances pertaining the normal order which adds disgrace and obligate to the material injury caused the crime. Applicable crimes against the chastity rape included lesser use physical injury, light or grave coercion, and murder. Requisites: crime must be against chastity less than serious physical injuries, light or grave coercion, and murder. The circumstances made the crime more humiliating and shameful for victim. Example: accused embraced in the kiss in the offender party not out of the lust but out of anger in front of any people, rape in the front of the husband, rape successively by 5 men. 10. To make effect the crime more humiliating, ignominy not present where the victim was already dead when such act were committed against his body or person. 18. That the crime be committed after an unlawful entry. Unlawful entry when the entrance is affected by a way not intended for the purpose meant to effect entrance and not exceed. Why aggravating? One who acts not respecting the walls erect by means to guard their property and provide for their personal safety shows greater perversity and greater aquacy, and hence the law punish him with more severity. Example, rapist against entrance through the window, inherent in trespass to dwelling, robbery and with force upon things, and robbery with violence or intimidation against person. 19. That means to the commission of the criminal, a wall, roof, door, or window be broken. Requisites: 1. A wall, roof, window, or door was broken. They were 2 is they were broken to affect entrance. Applicable in only if such acts were done by the offender to effect entrance. Breaking is lawful in the following instances. An offender other to make an arrest may be break open the door or window or any building in the which person arrested or reasonably believed to be an officer of refuse admittance may break open any door or window to execute the search warrant or liberate himself. 20. That the crime be committed with the aid of persons under 15 years of age or by means of motor vehicle, airship, or other similar means. Reason for number 1, the repress so far as possible the frequent practice resort to by professional criminals to avail themselves of minor taking advantage of their responsibility. Example, one instructed 14 years old to climb up the fence and open the gate for him so that he may rob the house. Reason number 2, the counteract the great facilities found by modern criminals in said men to commit crime and flee abscond once the same is committed. Necessary that the motor vehicle be important tool to the consummation of the crime. Bicycle not included. Number 21, that the wrong done in the commission of the crime be deliberately argument by causing other wrong not necessary for its commission. Cruelty, when the culprit enjoys and delights the making his victim suffer slowly and gradually, causing him unnecessary physical pain in the commission of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of the deceased, has to be proven. 1. Mere plurality of words do not show cruelty. No cruelty when the other wrong was done after the victim has died. Requisite that the injury caused in the duration increased by causing other wrong. 2. That the other wrong be unnecessary for the execution of the purpose of the offender. Ignominy, moral suffering subjected in humiliation. Cruelty, physical suffering. Article 15. Alternative circumstances. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effect of the crime and the other condition attending the commission. They are the relationship, intoxication, and the degree of instruction and education of the offender. The alternative circumstances of relation shall be taken into consideration when the offender parties in the spouse, ascendants, descendants, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. The intoxication in the offender shall be taken into consideration as a mitigating circumstances when the offender has committed a felony in the state of intoxication, if the same is not habitual or subsequent to the plan committed said felony, but when the intoxication is habitual or intentional, it shall be considered as aggravating circumstances. Aggravating alternative circumstances, those which must be taken into consideration as aggravating or mitigation according to the natural and affected of the crime and other condition attending its commission. Relationship, taken to the consideration when offended party is the spouse, ascendants, descendants, legitimate, natural, or adopt brother or sister or relative by affinity in the same degree of the offender. Number 2, intoxication, mitigating when the offender has committed a felony in the state of intoxication if the same is not habitual or subsequent to the plan to commit the said felony. Aggravating if habitual or intentional. 3, degree of instruction and education of the offender. Relationship, mitigating circumstances. In the crimes against property, robbery, usurpation, fraudulent, insolvency, arson. Exception, Article 302 of CC, no criminal liability, civil liability only for the crime of the thief, swindling, or malicious mischief committed in the cause of mutual by spouse, ascendants, descendants, or relative by affinity, also brother and sister, brother-in-law, or sister-in-law, if living together, become as an excepting circumstances. Aggravating circumstances, the crime against person in the cases where the offender or when the offender in the offended party are relatives the same level as killing a brother, adopted brother, or half brother, always aggravating in the crimes against chastity. Intoxication, mitigating circumstances. A, in intoxication is not habitual. Aggravating circumstances. A, if intoxication is habitual, such habit must be actual and confirmed. Mitigation and circumstances. B, if intoxication is not subsequent to the plan to commit a felony. Aggravating circumstances, if the intentional subsequent to the plan to commit a felony. Must show that has taken such quantity so as to blur his reason and deprive him of a certain degree of control. Habitual drunkenness given to the inebriately or the excessive use of intoxicating drinks. Habitually drunkenness must be shown to be an actual confirmed habit of the offender but not necessary or daily occurrence. Degree of instructions and education, mitigating circumstances, low degree of instruction education of the lack of it because he does not fully realize the consequences of his criminal act, not just mere illiteracy but lack of intelligence. Aggravating circumstances, high degree of instruction and education, offender avails himself of his learning in committing of the offender. Determined by the court must consider the circumstances of lack instruction. Exception not mitigating. 1. Crimes against property. Number 2. Crimes against chastity, rape included. And the last is crime of the treason. And that's all. Thank you.